and welcome to the Divorce Lab. We're a group of independent professionals working to help educate the public on various topics related to divorce. I am Carrie Goldring, a certified divorce lending professional who specializes in mortgage planning.
And I'm Mark Avezai. I'm a certified divorce financial analyst. I work primarily in Troy, Michigan.
Hi, I'm Jim Chryssikos. I'm a family law attorney and mediator located in Troy, Michigan. So let's get started with today's show. I want to throw you a curveball and get away from the domestic violence and abuse stuff and ask you probably the most commonly asked question I get that could involve a criminal attorney. And that is, I think my spouse has hacked into my phone or hacked into my computer because they know things or have things that there's no way that they should have. What does this fall under in terms of any criminal statutes and what can be done, if anything?
Yeah, that is really, really common. In fact, we've even had a case where a client put a device and a plug in the bedroom where they had a camera and a microphone where they could watch their spouse sleep because they thought they were cheating on them. In many cases where they're logging into cell phones and computers and email. Mm-hmm. And about 15 years ago, there was a case in Michigan where a husband was prosecuted for going into his wife's email. It was the first case of its type. And ultimately, he was convicted of unlawfully accessing a computer, which is a felony in Michigan. Not only is that a felony, but breaking into a computer, unauthorized access to a computer, but also just using a computer to commit a crime, whether it's a felony or a misdemeanor.
Do those fall under the eavesdropping or wiretapping acts, or the totally separate, the computer access or phone access? It's totally separate statutes.
Yeah, totally separate statutes. In Michigan, there's federal and state statutes that apply. Federal statutes are almost never used to prosecute those types of crimes, but there are state crimes that are right on point, and state prosecutors are more than willing to prosecute those cases if they can determine whether or not they were committed. And they're so good now, investigators, at investigating those crimes. They can figure out when someone logged in, what time it was, where they were at. You know, if the spouse can prove, the person who owns that account can prove they weren't there, they were at work maybe, and their phone was accessed from their iCloud account, or their email was accessed from their home when they were at the office, that's a pretty easy case to prove that the spouse is the one who did it.
So let me ask you the most common scenario. Somebody says, well, we have an iPad that the whole family uses. Everybody knows the password, or there is no password. I was able to go in there, and all I have to do is log in the password that everybody knows. It's a shared device. And I looked at his or her email, and I saw emails from their girlfriend or boyfriend. Okay. So what about that scenario? You've got a shared device, or it has a passcode that everybody knows, but you look at somebody's email on that device.
Sure. So that's a very good question. That's a tough case for a prosecutor to take and prosecute, because the defense can easily argue that this is a situation that each spouse was given permission to review one another's emails on this shared device, evidenced by the fact that there's no password to get into it. And unless there's some either direct or circumstantial evidence that that permission was withdrawn, it's unlikely a prosecutor would take that case.
And I would think it would be the same answer for a password protected device if it's a known password. If your spouse or your kids know your password, even though you do have it protected, everybody knows it.
That's an easier one, and much more likely for the prosecutor to take, actually, because if there's a divorce that's pending and parties are not using the same device, it's much easier for the prosecutor to make an allegation that they believe a jury would agree with, that the spouse should have known at that point, when there's a divorce pending, that they no longer had permission to access their spouse's device. A prosecutor might be willing to take that case.
Well, what if it was before the divorce was pending, and that's why there's now a divorce pending, is I found something that I wasn't expecting to find?
Yeah, if there's a history of sharing that device and sharing the password and allowing one another to go into your email, it's very unlikely a prosecutor is going to file charges.
It seems like you have an expectation of privacy, or it seems to still be the test. If I don't expect anybody's going to be able to go onto my phone or my tablet then I have that expectation of privacy.
Yeah, it'd be one thing if you share the password. It's another thing if your spouse looks over your shoulder and sees you typing it into your phone and then uses it, and that would be a clear invasion of your expectation of privacy.
So Jim, question, what happens when you're doing like a collaborative divorce where no one's filed anything?
Well, in a collaborative case, I mean, you're talking about looking on somebody's device.
Mm-hmm.
Yeah, I would say that would be a pretty big breach of the collaborative participation agreement, because it's, you know, everything in collaborative divorce is upfront, transparent. We're not going to hire investigators. We're not going to do discovery. It's all going to be voluntary disclosure. And I guess I would say if it were my client who did that, I would say, well, maybe this case shouldn't be in collaborative, because if you are so concerned or so suspicious that you need to go on your spouse's device, maybe it's not the right fit for collaborative. You know, maybe there's a better way to get that information if you're already in the collaborative process, rather than, you know, secretly going on their device, which could land you in some hot water, as we're hearing.
And Jim, you can answer this better than I can for sure, but I've certainly seen situations where there's a divorce, probably not a collaborative one, where there's either interrogatories or a deposition, and there's questions about whether or not someone has accessed their spouse's email. And such person would really be in a bind to answer that question honestly, because they would implicate themselves in a crime, or if they lied, they implicate themselves in perjury. Another reason we oftentimes get calls from family law attorneys saying, hey, I had a consultation with my client. They admitted that they've done something that they shouldn't have done, and I know that it's going to be asked about. We need you to consult and help us determine whether or not they should take the Fifth, meaning assert their right to remain silent under the Fifth Amendment.
Yeah, absolutely. If you know it's coming, consult with a criminal attorney ahead of time. You know what the question is coming. You know what your response is going to be. And if I was blindsided by that in a deposition, I would certainly advise my client object first, and advise my client to assert the Fifth Amendment privilege, and then we let a judge sort that out later. But obviously, if a question is asked that could result in a criminal prosecution, you have to advise your client to assert their Fifth Amendment privilege and object to that.
I have a financial question to kind of add to Jim's line of questioning here. And if there's a joint account, let's just say, you know, a couple has one account for whatever, you know, whatever reason, it's their only joint account, and one spouse chooses to drain that account or take a significant amount of money from that account that is you know, going to leave it impossible to get half. Let's say, you know, the assumption is half would go to each spouse, but there's not half to give anymore because one spouse has taken more. Is that a criminal discussion at this point?
So we get calls from typically to lack of a better word, a victim of that happening, a spouse whose assets have been drained from their bank account by their soon-to-be ex-spouse. And they ask, hey, is this criminal? Can I press charges for that? And the answer is usually not. If it's a marital asset, it's not criminal if one spouse abuses the trust of their other and takes those funds. Occasions where that might be criminal would be if they were premarital funds, if it was protected by a prenuptial agreement, or potentially if there's a court order ordering one of the spouses, a status quo order, for example, saying you can't take those funds, and then someone does. I've certainly seen detectives get involved and at least want to speak to someone about whether or not, and determine whether or not that's a crime.
And certainly if they did that in violation of a court order, they might be subject to criminal contempt charges.
Yeah, absolutely. And criminal contempt charges are very similar to a criminal prosecution with a little less formality. You might not have a right to a jury trial. You might not have a right to something called a preliminary exam, which is a hearing to test the evidence to determine if there's enough evidence to go forward to a trial, but very much like a criminal prosecution where there's evidence of guilt that's introduced, and then evidence, hopefully, that's exculpatory or to show the person isn't guilty of a crime, and then the judge can sentence the person who's convicted of criminal contempt to jail and hefty fines.
And then you hope there are other assets there if the money has disappeared or gone overseas, that you can balance it out somehow and compensate the victim,
Yeah, you hope at that point that the money's not gone.
whether it be maybe real estate money, real estate assets or retirement assets. The easiest to take under Mark's scenario is cash in a bank account, right? A little tougher when it comes to pension, 401k, real estate, not as liquid, obviously.
So can I wrap it up with a mortgage question? Sometimes when I'm working with people who are refinancing their home and will find a home equity loan that a spouse signed the other spouse's signature on them and they were unaware of it, or a mortgage that comes up somewhere that usually it's one spouse signing the other spouse's name. And no one ever seems to, I don't know, want to do anything about it. I don't know if it's because it's not worth it or it's just too hard of a thing to go after. But I do see that come up, if you can comment on that.
Yeah, actually, in Michigan, both, and also in the United States government, there's a crime called identity theft. And if you use someone else's personal identifying information, including their name, social security number, date of birth, to do something in their name, like, for example, get an equity loan or get a loan, then that is a felony that's punishable by a mandatory 2 years in prison. So that is definitely a crime, and someone would be subjected to considerable time in prison if they were to do that. And I know it happens frequently.
And is the spouse, so the spouse is the one that had their signature forged, would have to be the one to press charges, correct?
It could be them or the financial institution, but typically it's the person whose signature and personal identifying information was used. And that wouldn't be a crime of stealing money because, you know, it could be arguably a marital asset if it's coming out of the home, the marital home. But stealing the identity is a separate crime in and of itself. Not to mention, like I said earlier in our discussion, it's also using a computer to commit a felony is a separate felony on top of that.
Interesting. Well, thank you for your time. If anyone wants to get a hold of you, what is the best way for someone to find you?
Sure. Our office is located in Southfield, which is in Oakland County. We service clients throughout southeastern Michigan, and our phone number is 248-263-6800, or someone can go to our website, which is www.notafraidtowin.com.
Perfect. Well, we
Great.
thank you so much for your time, and we'll definitely do this again.
All right, great. Thank you guys so much. Thanks,
Thanks,
Jim.
Loren.
Paul.
Thanks,
Thank
Loren.
you.
Thank you for listening to us today. You can find us on the divorcelab.com. You can feel free to take a look at our other episodes, and you can also leave some questions or comments for us on there as well.